last events to enjoy her presence. And so please send her your well wishes in the coming months while you have the opportunity. Without any further delay, I am going to introduce our first speaker for today, Dr. Tammy Garland. Dr. Tammy Garland is a professor of criminal justice in the UTC Department of Social, Cultural, and Justice Studies. Dr. Garland received her bachelor's degree from the University of Kentucky, a master's degree from Eastern Kentucky University, and a doctorate from Sam Houston State University. She primarily teaches courses in drugs and crime, victimology, juvenile justice, and crime and popular culture. Her current research interests include popular culture and crime, juvenile bullying, drug policy issues, and the victimization of women, children, and the homeless. Her publications can be found in the following journals: the American Journal of Criminal Justice, Criminal Justice Policy Review, Criminal Justice Studies, Journal of Aggression, Maltreatment and Trauma, Journal of Ethnicity and Criminal Justice, Journal of Feminist Criminology, Journal of College Student Development, and Southwestern Journal of Criminal Justice. In 2018, Dr. Garland co-authored a book, A Unified Theory of Justice and Crime, Justice that Love Gives, addressing criminological theory and the human condition. Dr. Garland is involved in a number of service activities at the university, community, and professional levels. Currently, she serves on the board as a board member for the YMCA, Chattanooga Community Housing Development Organization, and the Moccasin Bend Mental Health Institute. She also works with a number of local agencies to aid those in need, including the homeless population. Additionally, she serves as a manuscript reviewer for a number of peer-reviewed journals, serves on a number of disciplinary committees, and works with a number of agencies as a program evaluator. In 2011 and in 2018, she was awarded the Outstanding Service for the College of Arts and Sciences for her service to the university and the community. She also received the UTAA Public Service Award in 2018, Dr. Carolyn Thompson and Roger Brown Community Engagement Award in 2018, and the Harold Love Outstanding Service Award in 2019. And on a more personal note, Dr. Garland lives with their husband and their 2 children, along with a myriad of pets. They spend much of their time camping, playing tennis, attending sporting events, and hiking with their dogs. And without any further delay, I would love for us to give a warm welcome to Dr. Tammy Garland.
Thank you all for having me here today. Today we're going to talk about terminology, but before we get started, please know that, well, most of you know that the juvenile justice system is completely different than the criminal justice system. But I always get the proverbial huh when I'm trying to talk about the juvenile system with people who are so immersed in the criminal justice system that they don't really realize that there are differences, especially when we're talking about levels of delinquency. So I usually always give the answer that students will ask me, or people in the community will ask me a question. I will say it depends, and it depends because the juvenile justice system isn't like the criminal justice system, because it's based on this idea of parens patriae, which is the state as parent. The juvenile justice system, in theory, is supposed to be based on this idea of rehabilitation, where we will do what's in the best interest of the child. And I like to say, if you think about the criminal justice system, it's kind of the Grimm's fairy tale version compared to the Disney version of the juvenile justice system. Now, I'm not saying the juvenile justice system isn't harsh, but it is much less harsh to the criminal justice system, except maybe if we're looking at Florida. Yes, Florida, we are looking at you. Okay, so let's talk about delinquency and this idea of what is criminal behavior. Now, when we think about criminal behavior, when we call people criminals, we're talking about adults. Juveniles aren't called criminals, they're called delinquents. And a delinquent act is any offense committed by a juvenile that would be classified as a crime if it was committed by an adult. So when we think about this idea, juveniles are subject to the same violations, but there's a catch. Juveniles are also subject to what we consider status offenses. A status offense is an offense that would not be considered a crime if it were committed by an adult. So you have things like truancy, running away from home, incorrigibility, that are all considered delinquent acts, even though they are merely status offenses, and if you were an adult, wouldn't be considered criminal. Now, when we think about juveniles, we have to think about adolescents, okay? Typically, well, kids coming into the system aren't little kids. We're typically looking at adolescents, okay, who are in the second decade of their life, usually 10 and above. Okay, so adolescent development is the process which biological, cognitive, emotional, and social development unfolds and interact during the second decade of life. So we have to look at these individuals because they have all kinds of influences. And the issue here is they can't be treated the same because they do not have the same developmental maturity. Juveniles are developmentally immature, okay? So they don't have the same thinking, reasoning, and decision-making processes that adults do. I know you've heard everybody say, if you can't do the crime, if you can't do the time, don't do the crime, okay? I always flip that. And what happens is it's this idea that we try to hold juveniles to the standards of adults. And people will often tell me all the time that 7-year-olds know better. Well, there's a difference between kind of knowing better and not really knowing better, because juveniles aren't really culpable, okay? They aren't really blameworthy, because what we see is they can't engage in that logical reasoning. So cognitively, we know by science tells us that a juvenile doesn't fully understand, as brain development doesn't stop until their early mid-20s. Now, theoretically, we know this. We know the juvenile justice system began at the turn of the 20th century to basically address these issues, to be the status parent, to come in and intervene and protect these kids. But we often don't do that in practice, and historically we haven't done that in practice. Now it's becoming, especially with science and being able to analyze people, it has become more important. The Supreme Court has made decisions in Roper v. Simmons, which eliminates the death penalty for juveniles, Graham v. Florida, and Miller v. Alabama, which also takes into consideration this cognitive ability that juveniles have. Now, it's not just us that we need to think about when we're looking at cognitive ability. When we address juveniles, we also have to use developmentally appropriate language in this whole process, because what happens is if we don't, we have a problem. If any of you have children, you have heard them say, I know, to every single answer that you say. I'll tell my kids something all the time, and they'll be like, I know. Well, they really don't know, okay? Brains don't just start, and cognitive reasoning ability don't start to resemble adult thinking until about the age of 16. But then they still don't understand. And oftentimes it's not just cognitive development, but it is cultural. It is region, things like that. And so they may say that they know and that they understand, but but simply being able to understand a word doesn't mean that it's appropriate language and they really understand the ramifications. So let's talk about how the language differs in policing, courts, and corrections. And I tell this like I tell a story. How do you get in? So we're going to kind of follow the path. We'll waiver in different places, because what happens is certain things happen sometimes at different places at different times. I'm just going to give you kind of an overview. So most of the time, 80% of the youths who come into contact with the criminal justice system come into custody because they interact with police. Now, this doesn't mean that the police are out targeting juveniles. This basically means someone is typically calling or something's happening, and it could be a probation violation. And so what happens is they're going to end up in taken into custody, okay? This is the same thing, but as are being arrested, but we do not say that juveniles are arrested. We say that they are taken into custody, because we do not want to stigmatize juveniles. Now, officers have a tremendous amount of discretion when it comes to taking juveniles into custody. So they don't necessarily have to do it unless it's something that is a harm to themselves or to an individual, and it's a more of a minor level crime or delinquent act. Let's call it delinquent act. Then they can, just give them a citation. Now, if it's something major, they're probably not going to give just a citation, and they're going to take them into custody. So when we look at that, when they're brought into custody, we basically call this intake. Okay. Basically, intake is a screening and assessment process of children. Okay. Prior to seeing a judge, we're going to have an intake officer who's typically a probation officer, typically, not always, basically evaluate youth to determine if that youth is appropriate for release, okay, appropriate for an informal diversion program, or if they should be referred to for prosecution, okay? And so when we're looking at this, they have a tremendous amount of discretion as well. So oftentimes, and this can happen prior to also sentencing, which is not really sentencing in the juvenile justice system, but we look at social history. You can take a social history report, look at records, basically look at their family history, all of this, making those decisions. You can also do a risk assessment, okay? And risk assessment looks at the history and likely to predict offending. Okay, and this also happens at different levels of the system. This happens from the beginning, and it can also happen at the end when they're being released from a detention facility. So those words are used often interchangeably, and we'll talk about it. It becomes weird because we do say these things interchangeable at times. So when we're looking at this, a juvenile is petitioned, okay? So when we're looking at a petition, it's basically a court document that you're going to bring a youth into the system. Now, we need to know that not every case that is petitioned to the court that comes into an intake officer. Of over about 800,000 cases, only 57% are nationwide are petitioned to the juvenile court. Okay, they can be diverted. Okay, now diversion is typically an informal process, but it can also be used as a formal process. And when we do this, it keeps kids out of the system, because there's all kinds of problems with, once a kid gets into the system, oftentimes it's hard to get them out of the system. So your intake officer and all the juvenile court actors are going to try to keep them out of the system. Okay, so we do have an initial hearing, and this is the first hearing that a kid will go to, and that they will be in front of a judge. Okay, and it varies based on different jurisdictions. We also, an arraignment is a portion of that initial hearing. Okay. And so if they're arraigned, they're brought before the court and they must deny or admit charges. There is language that is often differs this. Usually don't admit guilt, but in the law it does say guilty in Tennessee. They can deny the petition, but they're actually pleading guilty. Okay. Now you must have a detention hearing. Okay. Must be held 48 to 72 hours. You have to show probable cause in 24 hours. So you can't just hold juveniles indefinitely. So you have to actually bring them, have someone in. Now, one of the things we need to think about is not only do juveniles have a right to counsel, and yes, they have a right to waive counsel. I have problems with this. That's a conversation for another story. But they also have the right to a guardian ad litem. Basically, this is an attorney who will be appointed to represent the best interest of the children. In Tennessee, it's an attorney. If we cross the border into Georgia, it does not have to be an attorney. You also have to show that there is competence to stand trial. Basically, you can consult with a lawyer, you have the understanding of the proceedings, yada, yada, yada. Now we can question this of if does a juvenile truly understand or not. You also have an adjudicatory hearing. Okay. This in the criminal justice system is what is referred to as a trial, but it is adjudicatory hearing because it is a fact-finding phase of the juvenile case. Remember, though, we have to remember that almost half of all cases that are petitioned to the courts are not adjudicated. So oftentimes even they will be given diversion, and diversion is not this is not typically true diversion, because diversion typically is an informal system, but we use those terms to try to get kids into programs. One thing that Craig will talk about later is deferred adjudication has gone away. You now get diversion. So this is, once upon a time, judge would be able to say, okay, you're not going to be adjudicated guilty, but I am going to basically sentence, or no, I shouldn't say sentence, put you in a diversion program, and if you complete it, then it will go away. And that has since gone away. Now, adjudication of a delinquent means that they have been in the adult system, would have been convicted. You are adjudicated in the juvenile system. And so that is basically where you have pled guilty or not. Okay. Now you can plea out. This is called an adjustment. This is a formal adjustment. You can do informal adjustments, but this is a formal adjustment. There's also when you are adjudicated, now you're going up for sentencing, which in the criminal justice or in the juvenile justice system is called disposition. Okay. And typically there is a predisposition report. There is a disposition hearing. Okay. And that predisposition report is bringing in that social history. The disposition hearing is looking to see what we're going to do with you. And then the disposition is what they're actually going to do with you. Now, the idea is with a disposition that we're going to focus on rehabilitating children. Okay. So we're going to try to do what's in the best interest of the child. You can pay restitution when you don't really consider paying fines. You're paying restitution to society. You can do community service. You can be placed on probation. You can be committed to a facility. And this is typically handed down through a disposition order. Okay. And basically it's a written signed document. It's basically signing off. Post disposition, basically it is the period after disposition, okay, after that sentencing phase, and it includes things that are, you know, that allow counsel to represent a juvenile still. So it's whether they're going to appeal, whether they're going to represent you in probation and parole violation hearings, all of those things within the system, because you are guaranteed the right to counsel. Now, when we look at being sentenced, there is so many there are avenues that a judge could take. Okay, you can be diverted. Okay, and that's basically being put into programs that may help you. Okay, you can also be put on probation. So if you're put on probation, basically it's an alternative to being incarcerated, which is detained in the juvenile justice system. And I'm about out of time. So, and so basically a probation officer is going to supervise you. They're overworked and underpaid, but they are going to supervise you. So you don't have to be detained. And detention is basically incarceration. We don't like to call it that. You can have secure detention, okay, where they are locked in a detention facility, or you can be placed in a group home, a shelter home. And then you can have at-home detention where you're monitored. You can also, if and Judge Filliall will talk about this, I won't talk about this much, you can be transferred to adult court if your crime is considered serious enough, and I'll let him talk about that. We oftentimes don't consider all the problems, okay? There's collateral consequences, and when I say collateral consequences, the problems not just about being adjudicated in the court. There are issues. There are ineligibility for programs. You could possibly lose your voting rights. All of these things, they're not generally applied to juveniles, but they can if you're transferred to adult court. So you have to look at all of these issues, especially if once you're in the juvenile system, you're more likely to end up in the criminal justice system. One other thing, you can be released. We don't consider it parole. Once you are released from a detention facility, we do have what we consider aftercare. Okay, it is basically the same thing as parole, but we do not use that term because it is extremely harsh. All right, I am out of time, so I will stop there.
Thank you so much, Dr. Garland. I know that I got some clarity from your talk that I didn't even know I needed. The terminology is used so interchangeably in casual society that it's easy to be confused what each of the terms means. So thank you for sharing that information with us. Just a quick reminder, if you have any questions, please click on the chat button. We will be answering those at the end of the presentation. And now I have the distinct honor of introducing the Honorable Robert Filliall. Judge Filliall, he presides over the Juvenile Court of Hamilton County. He has 7 full-time courtrooms with exclusive original jurisdiction for proceeding in which a child is alleged to be delinquent, unruly, or dependent and neglected. The courts that he rules over employ 96 dedicated professionals and relies heavily on volunteers and support agencies to make the lives of children in Hamilton County better. Judge Filliall is admitted to the Tennessee Bar, the U.S. District Court Bar, the Eastern District of Tennessee Bar, and the 6th Circuit Federal Court of Appeals. He graduated from the University of Memphis with his Juris Doctorate and his undergraduate at Christian Brothers University. And Judge Filliall has been married since 1988 to Dr. Kathy Filliall, a local pediatrician, and he has a son who is a recent graduate of UTC and a daughter who attends Lee University. So welcome, Judge Filliall.
All right. Good afternoon, all. I'm sorry I wasn't quite ready as I hoped to be. I wanted to come to the podium today to address you all, and I wish we could be in person. And I trust I'm being heard. Let's see. I am certainly unmuted, and it appears my video is on. Welcome. Thank you, Dr. Garland, for walking us through all that you did. That was good, really good information. And so in thinking about what I would talk to you all about today, Rosalind, suggested a couple of things and actually kind of changed courses as late as last night when I was, somebody sent me a link that showed a WebEx or a Zoom court hearing in which a litigant, there were about 12 boxes open, a lot of people there, but one of the litigants came on and the judge said, "Sir, what's your name?" And he told him his name, and he said, "Oh, so you're not," I can't even repeat it. It was so bad. The name that was in his Zoom box. I don't know if it was intentionally done or a very bad prank, but it didn't go well. It didn't sit well with the judge. During COVID, we've had some funny and some sad things happen in that regard, and thank goodness we're getting close to being back in person. And I wish I could be with you all in person today. So youth justice is indeed different than the criminal justice system in the United States, and Dr. Garland did a great job of outlining some of those differences. Since we are going back to in-person everything more and more, and I think we'll be appearing more and more in court. In fact, I look to hear from the Tennessee Supreme Court today on their suggested or directives on how we should go forward. I thought what I would do is talk in part about testifying in court and incorporate the subject into that, because you all, as children advocates, as support agencies, you just heard Amy say that, I've only got 96 employees here at the court, but I feel like we reach and do so much more than 96 people can do. And it's because of the volunteers, and even more so because of the agencies in our community who help us take care of families and children. And I can't thank you all enough for that. A parent has a fundamental right to parent their child. It's protected in the Constitution of the United States and in the Tennessee Constitution. And that right can only be infringed upon for very limited circumstances. And, removing a child from a parent, from a home, is a very serious thing, and it's not taken lightly. Now, we do it, of course. We do it sometimes in emergency situations. DCS has the authority to do it in emergency situations. Just example after example of some of the things I'm talking about. I'm going to try to avoid those examples too much, but I was meeting with a DCS attorney in a Hickson shopping center mid-evening Friday night on an emergency removal after mom delivered a 26-week baby who died exposed to methamphetamine, and the department wanted to remove the other two small children from that home until we could figure out what was going on. And so that was done on an emergency basis. And then, of course, in the youth justice, juvenile justice side, removing a child from a parent is sometimes done initially, of course, by law enforcement. As Dr. Garland pointed out, it's up to us to look at that situation at least within 24 hours. I can tell you that here in Hamilton County, we have a judge or magistrate on call 24 hours a day, 7 days a week. And we look at all arrests that come in, or all detentions, all custody situations from law enforcement that come into our juvenile detention unit within hours, usually just a few hours, at least to make sure that there's probable cause within the petition to show that this child should be there at all. And then if we do not make some provision for that child's safe release to a parent or guardian, then we have detention hearing at noon 30, at 12:30 every day on the next day. Our detention unit here, by the way, and I'm talking about Chattanooga. I'm in Hamilton County, Chattanooga. Not every county has detention units. Some are too small, but all the big counties have detention units. They're all temporary pretrial facilities. They're not intended to be rehabilitation facilities. They're meant to be pretrial if and when we have to detain a child, because there's no other safe way to release the child. We try hard to release. In fact, we only have 7 in our detention unit today. And in February, we topped 20 for the first time in over a year. But it's low population, very low stay. And yet, for those children that we do see in the juvenile detention unit in Hamilton County, not only do they eat well, and we try our best to take good care of them, but they see a medical provider, sometimes for the first time in a long time, and there's a full-time teacher on staff to help those who do have to stay for some time. If they're in school, to help them stay current with their schoolwork, and for those that are not in school, to get their mind active doing something in the classroom where they are almost all day, every day, at least during the week. So testifying in court, there are going to be times when I would assume all of you are called on to testify in court sometimes on behalf of the child, or maybe it's not behalf of the child, but you've been called to court to testify for one reason or another. Testifying in court shouldn't be scary, but it is kind of an art. It is something that you need to prepare for. It is something that you need to think about. And what I thought I would do is just take a few minutes to kind of walk through some of those things, and then spotlight those things that affect youth justice or juvenile justice. As social workers of all kinds, and I know we've got a lot of agency people on today, you all are, of course, expected to be competent and professional. Judges are going to look to you as the experts in the area of child welfare. And to live up to that expectation, you need to know how to testify in court and be able to tell what you've done and what you're doing and what the child's done. Long time ago, another life, way before I even had a college degree, and certainly before law school, I was in the grocery business for a long time. I enjoyed that, meeting people, helping people, got excited about some things, and and then later I was a wholesale grocery buyer. Same thing. We dealt with groceries, we dealt with food, we dealt with seasonality and people. We found ways to compete among ourselves, which made it more fun for a young man. And then while my wife was in residency, I actually worked for a paper company that supplied to the grocery chain in the Southeast. I was a region manager for Fort Howard Paper Company, had the Southeast. Huge company, huge amounts of money that truckloads of paper that we handled in the Southeast, and did well with that. But just for kicks and giggles, my wife would drag me to a lot of social events, usually in the medical community in Memphis, where she attended medical school and residency at Le Bonheur Children's Hospital. And so a lot of spouses were, nurses or somehow in the medical field. So I get to those things, and, it usually came around, oh, so what do you do? And just for kicks and giggles, I just kind of acted real serious and said, I sell toilet paper. And, that always first got a jerk reaction, and usually a sip of a drink, but then later maybe a giggle. For us, we can say, and it thrills me to be able to say, and you can say the same thing, we work with children. We're not dealing with widgets or paper or goods of any kinds. We get to work with children. And now that's usually my response. You know, if I'm in a situation where somebody asks me, oh, so what do you do? I usually don't say I'm a judge. I usually say I work with children. And then if they press me and I'm forced to say, oh, I'm a judge, I'd leave it at that, so that the next question will be, what kind of judge are you? Which completely opens the door to say, well, I'm a good judge, and hopefully get a giggle. But it does give me an opportunity to talk about juvenile court and what we do and what we all on this call today are able to do in trying to impact children's lives. Okay, so going back to testifying in court in these types of situations, always tell the truth, of course, even if it hurts. You know, don't forget what your mama said about first impressions. You know, you don't ever want to be in a situation where you shade the truth or somehow damage your integrity, because like mama said, those things kind of stick with you. Second rule, basic rule, is don't be afraid to admit you didn't hear or understand a question. You know, most lawyers love the sound of our own voices, and you know, so no lawyer's going to mind repeating themselves, because we do like to talk, and you got one coming up next after me. When somebody says objection, you're answering a question, or you're about to answer a question, and you hear the word objection, you know to stop. Let the judge tell you whether it's okay to proceed with your answer or not. And the fourth big one is always tell the truth. Yeah, 1 and 4 are the same. So, you know, make a good impression. You know, you've got the child there that's relying on you, and potentially a parent who's trying to regain custody of a child or have a child released from a facility maybe. Make a good impression. You know, all those things. I'm not, if I were talking to a lesser group like college students or something, I would say things like dress appropriately, behave appropriately, body language is important, speak to the court with respect, even if you don't respect the judge. Remember that you are in court, and the court deserves respect. And you know, especially if you're represented by counsel, say you're a DCS FSW, and I don't know, I'm sure we have some on here today, but if you're represented by counsel, rely on your attorney. Help her or him help you. Meet with them, keep them up to date. And whether you have an attorney or not, all of these next things apply. And of course, do good work, you know, all the way through a case or a situation, a child situation. You know, do good work, because you know you may end up in court. At the very least, you want to do good work for the child and for the family. Before coming to court, review those notes, review the case file, maybe make some more notes. When somebody testifies in court who's been working with a child or has been involved in a case, it becomes evident pretty quickly when there's been sloppy work done. Just be ready, know the child's situation, and you know, don't be caught trying to flip through your file to find information that you should already know or remember about this particular case. And practice, maybe, you know, if you haven't testified much, and I've had some new FSWs on the stand recently, and I try to help them a little bit as appropriate, but it's okay to practice. If you're one of those that has an attorney, a DCS attorney or otherwise, ask them to help you. And you know, I'd say this too: if there's some weakness in your case, if there's some weakness that you know is going to come out, or maybe the other side, if it's an adversarial hearing, is going to point out, let your attorney know that, because it may be better to bring it up yourself and soften it than to wait for the other side to bring it up and to ask about it. So specifically with juvenile justice youth justice type cases. We here in Hamilton County, we review all of those cases pretty regularly. When we place a child in DCS custody, which is what we do with a youth justice child who can't be in the home, if we do have to commit to a placement, they obviously, well, not obviously, some of you may not know, they go into the custody of the Department of Children's Services Juvenile Justice Division. And so we don't just close our file and say, okay, that's that, we're done with that. We try to review those cases regularly, early, to ensure the child has been properly placed, to ensure that there's been good contact made between the caseworker and the parents and others, and make sure those connections have been made. This morning I reviewed a few. I've got one now who's been in detention for 54 days, waiting for placement. DCS says, well, they're fifth in line for a youth development center. Dr. Hargrove is going to talk more about the Juvenile Justice Reform Act of 2018 in a minute, and he may be very forgiving and cordial to me, but I'll just tell you, I was a harsh critic and vocal advocate for children during that whole process, and right now, I still believe that in Tennessee, we don't do enough to rehabilitate children who have to be committed. And the case this morning is not uncommon. That's a perfect example. That child is literally sitting and waiting for a bed and has been there 54 days now waiting for a bed. And under the Juvenile Justice Reform Act of 18, the law presumes that 6 months is enough. And so he's 2 months in and hadn't even started. But when we review those cases, and if you happen to be in one of those cases because you've been working with a child, the court's going to be asking questions, of course, when was the child placed? We know when was the child placed in the facility for treatment? Where, if out of state, why, and what did we try to do to avoid it? We've gotten better about that. We still have some children out of state, but not near as many as we did. The parent participation is key and very, very important. Credits earned. Those children in particularly with a determinate sentence. Indeterminate means no set time. In disposition, no set time. Work a program. Hopefully get a high school diploma. Get some A&D real treatment and other counseling, and come back and be better prepared to take on the world as a law-abiding, productive young person, determinate to a time specific. And so my jurisdiction in juvenile court across Tennessee runs out at age 19. So I could have it in a dispositional phase. I could say in juvenile justice custody until age 19. Well, that really doesn't mean until age 19, because each child is entitled to receive up to 16 days credit per month. 8 for behavioral issues and 8 for work in the program. And so obviously 16 is more than half, about half, but at least half, they can receive credit for that. So, that may be one thing that the court asks about, because I've had reports come back of where the child is raising Cain and not working a program and creating havoc, and yet still receiving 16 credits a month. And that's an issue for me when I see that, and so we look for that. We're looking for real parental involvement, because at the end of the day, that child, of course, is going to come back into that same home, in that same community, probably the same school, hopefully not the same group of friends, but the parental involvement, of course, is very, very key. So now you're in the courtroom. What do? You're on the witness stand. You've been sworn. You tell the truth. I might have already said that a couple of times. Stick to the facts. Unless you're asked for an opinion, try to keep your opinion to yourself, but just tell the facts. If you do express an opinion, be sure you can back it up with facts. Don't be afraid to say you don't know or you don't remember. Try to avoid jargon or acronyms. When I came on the bench here 8 years ago, I thought I had a pretty good handle with DCS. and other acronyms. I didn't. There were still many to learn, which, by the way, when I first heard about ACEs, and you all know about ACEs, when I first heard about ACEs, it was at one of Rosalind's events up in Ray County, Tennessee in 2013, I believe it was. And I heard about ACEs and I thought, oh boy, there's another DCS acronym. And I'm just being honest, I kind of tuned off the speaker, returned some emails or something and didn't pay proper attention. It wasn't until sometime later that I picked up an article, looked at the data, and really listened and realized how important adverse childhood experiences are in our work and how they affect children, how they affect adults. And I'm a firm believer in looking at those ACEs, the data, and knowing how it affects the children that we deal with every day. I'm in an empty courtroom except for Denise Cook, my court director, who's sitting over here with me because she's part of this group, but she is a trained ACEs trainer and knows how serious I am about knowing, and our people knowing, how adverse childhood experiences molds a child, helps a child. But you know what's great about that is we all know that those things can be overcome. They can be prevented sometimes, but even when they can't be prevented, they can be overcome. But anyway, try to avoid acronyms as much as you can. Don't fear cross-examination. Just be prepared and you'll be fine. Don't take things personally. And you know, when you're dealing with these issues, they are emotional sometimes. I can't tell you how many times. I mean, I don't know. I can't tell you because I don't know. And it's not every case, but there have been many cases, usually a transfer case. Termination of parental rights cases are very serious too, but it's usually a transfer case where I just have to go to my office, take a recess before the next case, and go and close the door. And I've sat in my chair in my office and wept on more than one occasion. I transferred a young man in a murder case a couple of years ago, and Rosalind is aware of this young man because he's so young. But it was one of those cases. I'd gone to my office, I'd closed the door. About 7 or 8 minutes later, I got a knock on the door. Judge, the assistant district attorney is out here in the hall bawling. That's the assistant district attorney who stood here and argued as to why the court should transfer that child to the criminal justice system. And it's that emotional sometimes. Nobody likes to do that. In essence, the district attorney is saying, Judge, you tried, you failed. Now it's time to wash your hands and send them on down to jail. And, you know, that happens not often. This has been an unusual week. I've transferred 3 this week. 2 of those were attempted murder cases where those older teenagers were literally accused of opening fire and shooting into a group of kids who were standing at a rec center. And the video was bone chilling. You know, what do we do with those in the juvenile justice system? 2 of the 3 this week had already been in DCS custody, had already been in a YDC, and sit back, and that's what we got. And so I know Dr. Garland mentioned I would talk to about transfers, and I know I'm out of time, but I did want to just talk about that just for a minute. The process is this. It's not just willy-nilly. It's not just look at the facts and make a decision. The state has to prove probable cause that they committed the offense, much akin to a preliminary hearing in a general sessions court. If they do, and the court finds that they prove probable cause, then the statute tells us to look at other factors, and those are simply, what is the child's record in juvenile court, if any? What past treatment efforts have been tried? What was the child's responses to those past treatment efforts? How did he or she do, and for how long? Was the offense against property or persons, with greater weight for transfer being given to those offenses that are against a person? Whether the offense was committed in an aggressive or premeditated manner, and whether the court can reasonably find that the child can still be rehabilitated in the juvenile justice system, youth justice system in Tennessee before his or her 19th birthday. And so those, just in a nutshell, are the factors that we look at. I'm out of time, but I'd love to, talk to any of you about those, at some point in the future, should you have questions. If you do have questions, I think we'll have an opportunity to ask some. I really wish we could all be together and I could see your faces and maybe even take a quick question or two. But I don't want to get into the break, and I certainly don't want to get into Dr. Hargrove's time. You're going to enjoy him. He is a lawyer and a colleague, and I serve on the Tennessee Children and Commission on Youth, in which he works full time. I serve as a volunteer commissioner appointed by the governor for a 3-year term, so I get to spend a little more time with him now than I did. But I'll leave you with this before he comes on. I was talking to a group of attorneys. There were probably 120 or so attorneys in a room, big room up at Fall Creek Falls State Park from across the state. They were mostly DCS attorneys. And so I was talking to them one day and trying to break the ice. I said, how many attorney jokes are there? How many lawyer jokes are there? And of course, I got answers like 1,000, 10,000, 10,642. When that died down, I said, no, there are only 3. All the rest are true stories. And with that, I'll let somebody introduce Mr. Hargrove after our break. Thank you all very much for letting me appear. Rosalind, thank you for this invitation.
Thank you so much, Judge Filia. And we are going to take a quick break now. So at 1 o'clock, we will resume with introductions of our next speaker. Thank you. Welcome back from our short break. Thank you so much for being with us. And I have the pleasure of introducing our next speaker. Dr. Craig Hargrove is the Deputy Executive Director for the Tennessee Commission for Children and Youth. Craig has experience advocating for children and families in private practices as Regional General Counsel for the Tennessee Department of Children's Services and as a referee magistrate for the Montgomery County Juvenile Court. In his work at TCCY, he staffs and directs the Second Look Commission. The Second Look Commission reviews a sampling of cases involving a second or subsequent incident of severe child abuse in order to provide recommendations and findings to the General Assembly. He also serves as the head of the Juvenile Justice Division at TCCY. He is married to his best friend and is the proud father of 2 sons, the oldest a cadet in the U.S. Coast Guard Academy and the youngest who is a senior in high school and will be attending Austin P University in the fall. So please welcome Dr. Craig Hargrove.
Hello. Thank you all for joining us today. Presenters have presented provided excellent information. I'm sorry, I'm timing myself. Let me make sure I get my timer going. There we go. I'm going to touch on some highlights of the Tennessee Juvenile Justice Reform Act of 2018. There have been some updates to that act from the current legislative session. So I'm going to try to touch on those as well. I won't get all of them because I haven't read through all of them. So if I say something and you know it's been changed by the current legislative session or the one that just ended, please drop that in the comment box. The other thing I think is important to acknowledge are a few things. So when making substantial changes to an entire system, there will be unintended consequences. There will be things that will require revisions or expansion of good work. And so the JJRA, I'm going to refer to it as JJRA, was, I think, a good first attempt to get some things right within Tennessee. Additionally, some of the changes that I'm going to mention were enacted based on the current practice at that time. And in other words, courts were doing the right thing. We just needed to codify it within our Tennessee code. And so I'm going to walk through some of those changes within the JJRA of Tennessee. And I say of Tennessee, I won't say it again, but I say of Tennessee because there's a JJRA Act of 2018 on a federal level as well. So I'm not going to be talking about the federal law. I'm going to be talking specifically regarding Tennessee. So I'm just going to walk through the statute and cover as much as I can, as many highlights as I can with the time that has been allotted to me. So in Tennessee Code Annotated 37-1 or 37-1-101, there's a particular provision that says this, and it talks about one of the purposes of all of our youth-related statutes and laws. It says provide developmentally appropriate interventions based on current scientific research in related fields, including neuroscience, psychology, sociology, and criminology. And so this is, although it's in the purpose portion of the statute, this is significant language. This language allows and acknowledges the most recent science and research and gives our youth justice system stakeholders like Judge Filion and people that provide services a greater ability to be trauma informed, which is where we would like to see our youth justice system headed. Going to 37-1-102, I'm going to hit on just a few definitions. The 15th definition is evidence-based, and I only mention that because if you are an attorney or practitioner, the definition for evidence-based in this portion of the statute is different than the term definition for evidence-based in the statute that pertains to DCS in 37-5-10 something. And so just keep that difference in mind. 22nd definition, preliminary inquiry, is a huge addition, then 2018 Act, a huge addition to our youth justice system. I think it was being done in some places anyway. So this language, preliminary inquiry, emphasizes the need to keep youth out of the youth justice system when possible. And so in our rules that govern what a preliminary inquiry is, it says one of the purposes of the preliminary inquiry is to provide for a resolution of complaints by excluding from the court at its inception. And so a major portion of the preliminary inquiry, and I'll talk about it later as it pertains to probation officers and YSOs, youth service officers, one of the major purposes is to exclude complaints from juvenile court at the inception. If there's no jurisdiction, if there's insufficient evidence, or the matter simply is not serious enough to be in front of the juvenile court or require judicial action. And then it goes on to say you can commence a proceeding only when necessary, and it's such strong language, only when necessary for the welfare of the child or the safety and protection of the public. And so I wanted to highlight that. The definition for probation. And so before the JJRA 2018, the probation definition included language about probation methods shall be directed to the discovery and correction of the basic causes of maladjustment. Thank goodness that language was deleted. It was archaic and very punitive. And so now the definition includes casework as a measure for protection and guidance and well-being of the child and the child's family. And so you can see that the JJRA is really moving toward a more trauma-informed youth justice system. And so the next definition I want to touch on is seclusion. And so it's the 26th definition. And so seclusion has been changed a couple times. The language was revised in the 2018 Act, and then later revised, or most recently revised, go into effect sometime this year. It still hasn't been signed by the governor, but I'm assuming it will. And so the 2021, the most recent revision that will eventually be signed by the governor, removes the following exception to seclusion prohibition. So this is no longer acceptable. Confinement to a locked unit or ward where other children are present, as seclusion is not solely confinement of a child to an area, but separation of the child from other persons. So now it is prohibited to seclude a youth by confining the youth in a locked unit or ward where other children are present. So I believe that's, in my opinion, not the official opinion of the Tennessee Commission on Children and Youth, but in my opinion, that's a step in the right direction. This most recent bill that will soon be signed includes the following language, and I'm going to paraphrase because it was an amendment to the bill that was originally submitted at the beginning of the session. And so a facility administrator, after a youth has been properly secluded or secluded based upon certain criteria, so the facility administrator is authorized to review the seclusion and then provide an additional 2-hour period if appropriate, and the youth must be 14 years of age or older. So after the initial seclusion, someone can review, and if necessary, 2 more hours, only if the child is 14 or older. There's a prohibition that the administrator cannot authorize more than 2 consecutive periods of seclusion. And so they can't just keep on extending seclusion by 2 hours, by 2 hours, by 2 hours. There's going to be a total of 6-hour limitation within a 24-hour period when that law is enacted. And then that amendment allows DCS to provide a rule or policy, some alternative options. So if a child's been secluded for a total of 6 hours and it's within the 24-hour period, and the child cannot safely be brought out of seclusion, then DCS has the authority to put some rules and policies together to address that particular issue. This new bill that will be signed also talks about how seclusion is supposed to be used. And so the 2018 JGRA says the use of seclusion is prohibited for punitive purposes pre-adjudication and post-adjudication. So the new language, which again, I believe is in a step in the right direction, says this: seclusion must not be used for discipline, punishment, administrative convenience, retaliation, staffing shortages, or for any reason other than a temporary response to behavior that threatens immediate harm to the youth or to others. And so this is also pre and post adjudication. And so the language that will be enacted this year is much stronger, in my opinion, and leaves less to interpretation. So I'm not going to talk about, I was going to mention validated risk and needs assessments. I'll just say this, that was added in the JGRA of 2018, and really the use of these assessments will help ensure that youth are receiving the services and treatment that they need, not some cookie cutter sort of thing, which happens sometimes, but not often, and then helps reduce disparities in treatment and services and length of involvement and length of stay. And so that's huge. So moving to 37-1-105, looking at subpart B, and it talks about probation officers, how they have the responsibility to conduct a preliminary inquiry. And that's why I spent so much time on the front end regarding preliminary inquiry. And so now as the probation officers review these complaints that are coming in, these charges of delinquency and unruly, they have the authority and the obligation, in fact, to make sure that the complaint is proper and do what they can within their powers, whatever the judge allows them to do, to exclude that matter at its inception if it's not proper. So the same language is in for youth service officers. I'm just going to mention that. That's in 37-1 or 37-1-106. Very, very same language. Next thing I want to hit on is informal adjustments, pretrial diversion. You can find that in 37-1-110. And if you look at that language that has been changed, but it was changed in 2018, the amended language sets the maximum time an informal adjustment can be extended to a total of 6 months. And so kind of what in different situation, but what Judge Filial was talking about. And so this language says for an informal adjustment, it's 3 months, and then you can only extend it one time for another 3 months. And so that may cause some issues if DCS or other stakeholders delay services or whatever. They don't delay. The delay happens and it can't be rectified immediately. That may cause some issues with informal adjustments. Still within that same statutory scheme, there is some discussion on, I think the professor mentioned it earlier, the juvenile has a right to not self-incriminate. So this language that was added in the JJRA of 2018 protects youth's Fifth Amendment rights, and it also helps ensure due process protection in informal adjustments and pretrial diversions, in that they don't have to make an admission to participate in an informal adjustment or pretrial diversion. And then any statement that is made during the preliminary inquiry within those confines is not admissible until the disposition hearing. And so it can't be used during the detention hearing. It can't be used during adjudication. But once they get to the disposition, some of that, if they make some admissions or make statements during the informal adjustment pretrial diversion period, that can be used during disposition. So something that's real cool, and I don't know if any jurisdiction within the state is doing it, but I do want to mention this. And so 37-1-115 has this new language, new in 2018, that allows law enforcement to develop its own youth diversion program to address misdemeanors only. They can't deal with felonies, but law enforcement can have their own program, diversion program, to address misdemeanors without court involvement at all. No court involvement, and I think that's huge. As was mentioned before, once it's the metaphor is the youth justice system is like a maze. You know, it's easy to get in, but sometimes very difficult to get out of. And so if a law enforcement jurisdiction wants to do this, first the jurisdiction must get the agreement, the law enforcement must get agreement from the court, juvenile court in that jurisdiction. And then it has to be developed within a collaborative effort. And there's certain individuals who are named in that collaborative effort. So moving to 37-1-120, it talks about petitions that are being submitted. And there's language in the JJRA that is designed really to narrow the school to prison pipeline by requiring schools to handle youth behavioral issues within the educational system when appropriate, and therefore by limiting the youth's contact within the system. And so if school personnel decides, or not decides, makes the decision based on the facts to file a petition, and so one, if those facts are based on acts that were committed on school property or during a school event, then the petition must show that the school personnel tried to use available educational resources to resolve the problem, and then must state that court intervention is necessary in the judgment of the petitioner. So that's huge, because we know a lot of our youth entered into the system through acts and behavior that occur at school. And so I think this new law will do a lot to help our youth to get the services that they need. It's one about attachment, but I'm running out of time. I'm scrolling through my notes. Oh, and so under Tennessee Code annotated 37-1-126, there is language regarding fees and how to assess those. And so the new language removes the child's financial resources from consideration when determining whether the guardian ad litem, which was mentioned before, whether that administrative fee should be increased up to $200. And so there's an overarching theme throughout the new act, the JJRA, that is taking financial responsibility off of the child, so that we're not having children languishing within the system because a fee wasn't paid and coming back to court, you know, every week or every month because a fee wasn't paid, but they've otherwise done everything that they need to do. So the new language, you know, removes the court's ability to consider the willful failure to pay the administrative fee. You can't consider that during the disposition of the case. Then it also makes it clear that the GAL, the guardian ad litem administrative fee, can't be assessed against the youth. And so under Tennessee Code Annotated 37-129 or -129, it's talking about disposition for delinquent acts or judicial diversion. And so I want to mention this. So the language within the judicial diversion proceedings seems to limit extensions of a judicial diversion to a one-time 6-month period. So for a total of 1 year. So if a youth is placed on judicial diversion, the maximum of that judicial diversion, and with a few exceptions, is 6 months. If that judicial diversion is required to be extended, it can be extended one time for another 6-month period for a total of 1 year. And then the order to extend a judicial diversion requires specific language. I'm not going to go through all that, and it must be in writing. And if someone wants to, if the language also states or requires that a petition is filed by whoever the supervising authority is regarding a judicial diversion, if they want to violate a youth based on non-compliance of the terms of that judicial diversion. So you can't just violate someone. Petition must be filed, and then the court must hear it, and then the court may require documentation regarding what efforts were taken to address that non-compliance. And so, but I think that was one of those things that a lot of courts and individuals were doing already. So here's when Judge Philial was presenting, he was talking about a youth that's detained for upwards or more than 50 days. And so in the JJRA, there's language that says that a court shall minimize the use of detention between adjudication and disposition. And in no event shall a disposition hearing be postponed or continued because there's a wait list for a suitable placement, unless that is unless it's waived by the attorneys. And so Judge Philial has his hands tied because DCS says there's no place for them. But this is exactly what this language, this new language in the JJRA, was developed to address that particular sort of issue. There's no reason that DCS should have that child waiting in detention for 50 some odd days for placement. That's exactly what this language is designed to prevent. So disposition of delinquent child, not in judicial diversion. And so there's language regarding when a child is placed on probation after found or adjudicated delinquent. And so this language seems to limit extensions with an S of probation to 6-month periods with an S. And so I say that because in some situations there's only like one extension, but if a youth has been adjudicated delinquent and then it's placed on probation, if necessary, and there's a bunch of regular rules and requirements regarding why you can extend, but it can be extended additional 6-month periods until it's necessary. And so there's time to get those services because the extension can be extended more than once, more than twice. As I read it, it may be indefinite. We don't want that, but it looks like that may be an option. I'd like to close that door at some point. And so again, if you want to file for non-compliant, if you want to violate someone for non-compliance of probation, a petition needs to be filed. I'm running out of time quickly, so I have about 2 minutes. Let me see what I want to highlight. Youth can't be placed in DCS custody for violation of probation unless the child has been adjudicated dependency and neglect, and that way they come in another way. There's a separately adjudicated delinquent act, not a technical violation, but another delinquent act and then they may be able to be placed in custody. And then the language kind of is almost like a catch-all. The court finds by clear and convincing evidence that the youth is in imminent risk of danger to the youth's health or safety and needs treatment or services, and get this, that are only available in DCS custody. And then there's a 6-month period, and then you can extend it for another 6-month period. As far as dispositions go, now this is going to be close to the last thing that I discussed, because I have less than a minute. I'm going to go just a little bit over. And so there have been several changes regarding the provision that talks about detention as a disposition. And so this legislative session, the previous language that was in the code and it was taken out by the JJRA 2018, is now back in. It's now back in the code and I think the governor's already signed off on this. And this is the language. It says placing as a disposition, placing the child in an institution, camp, or other facility for delinquent children operated under the direction of the court or local public authority. But this bill did something else. So if you read the bill and check out the bill summary, the detention as disposition portion of the bill, I think it's going to have some negative impact on youth. So the bill removes the 48-hour maximum time limit that a youth can be placed in detention for a disposition, and then removes the requirement that the detention can be served only on non-school days. And so I think that's substantial. I'm out of time. Rosalind, let me look through everything real quickly and see if there's anything else I want to touch on real quickly. There's a lot. The only thing I'll close with is
Craig,
yeah.
Craig, we have, you can have another 5 minutes.
Okay, cool. So I want to talk about transfers, and then I'm going to talk about something else. And so there's been some changes to transfers. Judge Phil, y'all talked about this, and if you want to look at it later on, it's 37-1-134 is where you'll find the transfer laws. And so the new language says youth may be transferred as an adult if the youth was less than 14 years of age at the time of the alleged conduct, and then charged with the offense of first or second degree murder or attempted first or second degree murder. And so that's a change, but the original language allowed that to happen anyway. These youth could have been transferred under the previous statutory scheme. And so the second amendment is youth can be transferred if they're 14 years of age but less than 17, and it keeps all the offenses that were in the original language, but then added the following offenses that are transferable, between 14 and 17. Aggravated burglary, especially aggravated burglary, and carjacking were added to that list. So the third amendment was youth can be transferred if they're 16 years of age or more at the time of the alleged conduct and charged with the offense of robbery or attempt to commit robbery. And they were transferable under the previous statutory scheme. And so there's really no difference there. One of the last changes regarding transfer was that if you were 17 years of age or more at the time of the alleged conduct, then you can be transferred. Doesn't matter what the offense is, as long as it's a delinquent offense. Of course, that the judge and all involved will go through those factors that Judge Phil y'all mentioned to make sure that it's proper. And so these youth could have been transferred under the previous statutory scheme. The major change with that particular provision is that the previous statutory language allows 16-year-old youth to be transferred for any criminal offense. And so this limits somewhat limits who can be transferred for offenses that are not these serious felonies. And I want to read language within the statute. It says, "It is the intent of the General Assembly that children shall not be transferred under this section due to a lack of appropriate resources or effective treatment and rehabilitation in the juvenile justice system." So to me, that's huge language. This language attempts to make sure that transfers don't occur because of a lack of appropriate resources, treatment, or rehabilitation. And so, because sometimes in past, I've been told that youth have been transferred because there's no services within our youth justice system to help them. And so this language says that we're trying not to make that the case. And so so maybe two quick things. And so with DCS, commitment to DCS, in the case where a youth has been adjudicated delinquent and committed to DCS for an indefinite period of time, that youth must be discharged or placed on home placement within 6 months or less. And then there's ways to extend past that 6-month period if certain criteria are met. And so I wanted to mention that. And lastly, it's the last thing I want to mention. Lastly, I want to mention real quick. And so use of detention. And so the new language for use of detention prohibits the use of detention as a disposition only in unruly cases. And so it allows disposition detention in delinquent cases. Last thing is financial obligations. If you go to 37-1-163, and I'm not going to read it all, but here's the in my opinion, one of the best things that this JJRA of 2018 does. It says it is in this new section. It's really part of a larger effort to make sure that youth are not within the youth justice system or continue in court jurisdiction or under supervision, informal adjustment or probation, or placed in state's custody or removed from their home due to the inability to pay financial obligation or restitution. So those are just some of the highlights. There's so much more that I could talk about. Take time to go through. If you have any questions, please don't hesitate to reach out to me. And that is, and like Judge Phil, y'all, I think I like the JJRA professionally more than Judge Phil, y'all, but know that it's not perfect, and know that there's a lot to be done. It needs to be changed, and if we have advocates like Judge Phil, y'all, and everyone on this call, if we have differing opinions, I believe all of our hearts in the right place, and we just need to keep chipping away at this to make sure that we get the best services and system available for our youth in Tennessee. And with that, I will be quiet.
Thank you so much, Dr. Hargrove. What great information for us. And now we are going to enter into our Q&A time. So if you have any questions that you have not posted in the chat, please take a second to do that. And just a reminder to use the chat button, not the Q&A button. And our moderator will review those questions and will provide answers. So we'll give you just a moment to do that if you haven't already.
Amy, this is Jill. We have some questions that came in throughout. So I will. Okay. In regards to a runaway situation, is there anything the Juvenile Justice Center can do to hold the youth more accountable with a delinquent offense in order for parent guardians to avoid becoming truant within the school district?
I don't mind trying to take that. Somebody else may have a better understanding, but I think I understand the question, and it's something that we encounter sometimes, and basically the answer is no. Unruly is one of those status offenses that Dr. Garland talked about, and it's incumbent on the parent to try their best to try to locate that child and help ensure the child's safe. Sometimes in those runaway cases, very seldom, we have a lot of runaway petitions filed here in Hamilton County. It's seldom that the child has actually run away. Usually the child is here in town with a friend or on a couch, sometimes couch to couch, and the parent simply doesn't do enough to try to secure that child. And that's not always the case now. I say things, and I don't want anybody to think I'm talking about absolutes. I'm just giving you, some examples of what we see. But unruly runaway is one of those status offenses. And to answer that question, just directly is no, there's not much we can do about that. But of course, if we wanted to talk about truancy, we could spend the next 2 hours talking about truancy. And, the schools have their hands full trying to keep kids in school always. Truancy's been a problem in Tennessee for years. And this year has, of course, created even new challenges that none of us ever thought of. But, truancy, the parent getting in trouble for their child being truant ought to be the least thing on their mind if their child has run away.
Can I interject? This is Rosalind, and I just want to say too that myself, along with the other 8 regional coordinators throughout the state, we actually monitor juvenile justice detention facilities. And this is one of the things that we look at, is that a status offender cannot be held over 24 hours unless it falls at a time that the courtrooms are closed, which would be the weekends and some Monday holidays. So one of the things that we're looking at is how long have you held that child in that facility? And I've run across in the past where people have actually tried to take that runaway situation and turned it into something else. And we find out that that's actually a violation of OJJDP. So we have to be really careful when we're dealing with the status offender as well. Not to be trying to charge them with something that they didn't do. So I just wanted to throw that in there because there are people out there that are monitoring this type of stuff.
One of the things that we should probably consider is, rather than being more punitive towards the juvenile, finding the parent better resources. And I think this is something that the whole system fails at, is not getting, there's obviously a problem if juveniles are running away. So getting resources for the parent and finding them some assistance, because putting them in a facility obviously isn't an option, and we don't really want to do that because that's probably not fixing the problem as is.
That's a great segue into actually our next question. Is there a training or assistance for the parents whose children are in the court system?
Well, that's where your audience comes in. That's where we rely on the agencies. And so to answer the question, there is some, answer as best I can. There's some, it's somewhat limited, everything from a 4-hour parenting class to actually, more intensive parenting counseling sometimes. But all throughout every stage of that process, we're trying, at least here in Hamilton County Court, we're trying to connect families to those services as best we can. And, we have, prior to the pandemic, we had almost every Friday at 11 o'clock, a different service provider come in and have a chance to talk to all staff, to make sure we understand who's doing what, who has capacity, and how can we help make those connections. So To answer that question, I would say yes, but limited.
I can tell you, I am, this is what I do. Juvenile justice is what I've been studying for 20 years. And I am also an adoptive mother and who adopted out of foster care. And I will tell you, getting services, and I know the services that are out there, is very difficult. I thought I was at my wit's end a couple of years ago because my son was out of control. And it was very hard getting help because he's a trauma kid, and being able to just decipher what he needs was very difficult, especially when he was able to manipulate and things like that. So I mean, it's extremely difficult to get these services. And it is extremely difficult for parents who don't have any knowledge of the system. So we really have to do a better job of that, I think. And like Judge Phil, y'all, there are programs out there, but sometimes we don't necessarily communicate with one another, and then what parents need isn't often being offered.
Especially when it comes to mental health care for children. We've got such a deficit, and the governor, I believe, has recognized that now. And I can tell you that the judges across the state, the executive committee of the Family and Juvenile Justice Judges Conference is going to take that on for the rest of this year, hopefully in preparation for the next legislative session as a real priority for us. And if we had time, I could give you example after example, but I just had a 12-year-old charged with killing his 12-year-old sister, and the evaluations that we could get for him, quite simply, are just insufficient. And when we went to to the state, all the way to Nashville, for help, and basically we found out that's all we have. We don't have anything any better than that in the state of Tennessee. So it is a big issue, especially locally and statewide, when it comes to mental health resources for children. But we do have some folks doing some great work, and many of them are listening right now, probably saying, here I am. And like Dr. Garland said, it's just making those connections is extremely difficult. And when I started here, I don't mean to get off on a tangent, but when I started here 8 years ago, I thought it was just me who had trouble keeping up with service providers. But I shortly realized it wasn't just me. It was all my magistrates. It's every judge across the state. It's an ever-moving target. And so I asked Denise Cook, who has left the courtroom now, but I designated her to spend half of her time, literally about 20 hours a week, working on relationships with service providers, making sure she knows who we can call on and keeping us updated. That's how important this group that Rosalind has on here today is to us and to judges across the state.
Thank you. The next question is, during the informal adjust time period, what supervision, if any, is provided to the juvenile? Is this the time that resources are provided?
Yeah, that's kind of a carryover, I think, for our last question. I think that is, I think everybody's pretty consistent across the state, that is exactly the time where we try to see what's going on and try to make those connections and provide some resources early on so that we avoid, more serious delinquency issues down the road. So I know it's not a strong answer, but the answer is yes. And there again, we rely on our agency providers for that very strongly.
Thank you. Does the amendment that youth must be discharged from DCS after 6 months affect the youth's ability to choose to age out from DCS custody? For example, in order to participate in supported transitional living?
So I'm not sure. Maybe I'm having trouble determining what the question is. So the amendment does not affect. Let me look at it again. Does not affect the youth's ability to age. No, the amendment doesn't affect the youth's ability to age out from DCS custody. If they age out, if a youth goes into custody and there's only 4 more months left of that child's jurisdiction in juvenile court, the child doesn't stay in an extra 2 months because of the 6-month period. That's a maximum. And so a youth can exit custody earlier if they've completed the program or age out before the 6-month period tolls. And then there's exceptions to that 6-month period. And so it's not a hard, fast 6 months and you're gone. As a matter of fact, I mean, there's language in the statute that says, you know, if treatment and rehabilitation of the child or requires, then the child can remain in state custody another 6 months to complete the programming. And so I hope that speaks to the question.
Yes, she said yes, it is. And she said to clarify if the youth had longer than 6 months but did not want to return home due to safety concerns.
Oh, so that's a totally separate. If there's safety concerns, then someone needs to make a referral to the DCS hotline and let DCS investigate or bring it up to the court's attention and go from there, I think. But I will defer to the Honorable Judge Filial regarding that.
Well, you know, I was trying to be quiet on this one, but thank you, Dr. Hargrove. You know, I don't see many juvenile justice kids aging out and being qualified for extension of foster care. They can't be in a YDC on their 18th birthday and qualify, is my understanding. But you know, that said, our extension of foster care program in Tennessee is strong. It's good. I think it's one of the best in the nation, and I'm very, very proud of it. And you know, encourage children, mostly foster children. You know, we have in Hamilton County on almost any given day, we have about 320 to 340 kids in DCS foster care situations. And some of those, you know, we try hard to get them out of foster care and to find permanency, like with Dr. Garland. You know, that's her son is a lucky young man to find that home, that permanent home. We try hard to do that. Sometimes we can't. Sometimes we fail. And when a child who's been in foster care turns 18 and has no family because, you know, I've terminated their parental rights because the state asked me to, or some other reason, it's our responsibility, you know, as a society to try to help them get off to a good start on their young adult life. And I think in Tennessee, we do a pretty good job. We need to do better at encouraging those children to take advantage of that. That's mostly what I'm doing is cheerleading, because many of those children, understandably, want the state out of their lives. They hear extension of foster care and they think, oh, I don't want any more of that. And in fact, so much so it's being discussed, and I hope soon extension of foster care is changed to some other name because of the negative connotations that foster children have for extension of foster care. We can call it something else and make it a little bit more appealing. But to answer that question, I don't think the Juvenile Justice Reform Act of 18 really caused that much harm as to that. And some juvenile justice youth do qualify for transitional living through extension of foster care, not near as many as our dependency and neglect foster children.
Thank you so much. Teens are struggling with increases in domestic violence, sex trafficking, suicide, truancy, and negative social media acts of behavior since the pandemic. To better advocate for community public safety, can someone please help me with evidence-based mental health resources in Tennessee for teens in crisis? If I may, I will interject a little bit here. We actually have a training coming up in July with Dr. Tim Perry with Frontier Health. He provided us with a training last May with the psychological effects of the pandemic and that social distancing and quarantine have on our youth. And he will be doing a follow-up in July that's still being planned, but kind of the long-term effects and what we can look for and how to address.
Yeah, that's a difficult question, Deborah, but and all of us are struggling with that. And as I said in just a few minutes ago, we the judges feel like pretty universally that we don't have enough resources for children's mental health in Tennessee, and I believe that's being recognized. And I know Dr. Hargrove, TCCY, does a lot of work in that area, and we'll be doing even more. You know, we need more psychiatrists. We need more psychologists. You know, if there's some way we could push college students, you know, toward that way, I mean, there's more need than ever. So I wish I had a better answer for you on that, but I did post in the chat just now. One facet of that is the youth suicide hotline number is 800-273-8255. I know what you're asking is a lot more, includes a lot more other than just suicide prevention. But I wish I knew a better answer to tell Deborah. Maybe somebody else does. But we do need to do more in Tennessee for children's mental health issues, and we're going to be taking that up, at least from the judge's standpoint, as much as we can to try to shine a spotlight on that need.
One of the things I posted in the chat was, many of you probably already know about this, but the behavioral health safety net that Tennessee just enacted. And basically any child from 3 to 17 can get free mental health care. And in the chat, you can link and you can find service providers. You know, it's most important, get a kid into therapy. I mean, that is, you know, waiting is probably the worst thing we can do. And getting them, if it's immediate, that suicide hotline is the first place to go. But sometimes, you know, sometimes kids don't reach out, or if they're struggling, we don't know. And a lot of times it's not simply suicide, but it's cutting and self-harm behaviors that we often don't see. And we know with COVID, a lot of kids are experiencing those things, and domestic violence. Those are some of the things that are happening. We don't yet see the results of mental health on youth yet. I think we have a lot of research to go, and we will start seeing as this progresses out. Yes, it's let up, but the long-term effects we won't know for a while. So, you know, just getting kids in mental health, I think, is the best we've got. Mental health services is what we have right now.
And our last question is, we used to have the order regulating conduct. Do we still have this available?
Dr. Hargrove may know better, more specifically. I don't recognize that as anything that we use here or have in a long time. So I'm really not sure. We do put down conditions, you know, and instructions sometimes. So we do orders trying to regulate conduct sometimes, but I'm not sure specifically. That looks like that's something specific, and we don't use it here in Hamilton County. I'm not sure what it is.
I'm sorry, Dr. Hargrove had to step away. He had another appointment to go to. But that's Lisa Wiley, who I know. We'll make sure that question is answered for you, if we can find an answer.
That is all the questions that I have seen in chat.
Great. Thank you so much, everyone, for your active participation in the session and posting great questions. And I don't know if you all feel the same way I do, but I could sit and listen to conversations on each of the topics that were brought up in the questions for a full day. There's so much to be learned here. So thank you to each of our presenters for the information. It was wonderful, very helpful. Thank you to Bill Latimer and Jill Stott for managing the interface for us today on WebEx. We really appreciate that. And just before we wrap up, I want to give another shout out to Rosalind LaBelle Rice. As I mentioned earlier, she'll be retiring at the end of August, and she has done tremendous work for children and youth in Tennessee. And I want to put out there that her retirement is out in August, so hopefully you'll have an opportunity to see her between now and then, and you can run up and give her a fist bump and let her know how much you appreciate everything that she has done for our community and for children. And we're not going to let her go away quietly, so we'll have more information about that coming forward. So thank you so much to everyone, and we look forward to connecting again soon. Have a great afternoon, and definitely take time to spend time outside. It's a beautiful weekend, and get outside as quickly as you can today. It'll be good for everyone. Thank you.
Thank you, everyone, and have a blessed weekend.